Hello, everyone. I hope you're all safe and well in these challenging times. It's my pleasure today to welcome you all to a discussion on funding infrastructure disputes. Today, I have the privilege to introduce our distinguished panel for this very relevant topic and moderate the session with my colleague Pratik Bagaria. Before I do that, I'd like the opportunity to briefly introduce Society of Construction Law's Young Leaders Group India. As we know, Society of Construction Law India is an organization of members drawn from all professions involved in the construction and infrastructure sectors, including industry representatives, legal professionals, and other experts such as quantity surveyors, programmers, delay and quantum experts. By encouraging the widest possible participation, SCL India aims to promote and grow the wider profession and the quality of the work by developing and incorporating best practices. Young Leaders Group was formed late last year as a novel organization under the umbrella of SCL India, focused on the development, research, and education in the field of construction law and associated topics for the future leaders across the various expertise and practices in the field. The group's founding steering committee includes Binsi Susan partner Sardul Amarchand Mangaldas, Amit George advocate, Ashish Bhan partner trilegal, Umar Ahmed partner Cyril Amarchand Mangaldas, Pragya Chauhan principal associate J Sagar Associates, Manvendra Mishra principal associate Khetan and Co, Shashank Garg partner Advani and Co, Padmaja Kaul partner in this law, and finally Pratik, my co-moderator, partner Singularity Legal, and myself. I work for a firm called FTI Consulting. Now, moving to our panelists. First, we have Ms. Sindhu Shivkumar. She's a senior investment manager at Innswell Advisors. Sindhu is a dual qualified lawyer and has worked previously with Simmons & Simmons, Allen & Overy, and Biden case before taking her present role at Innswell. She is responsible for originating claims, due diligence work, and active ongoing case management. Her portfolio spans the globe, and she's recognized as a thought leader in third-party funding by Who's Who Legal. Second, we have Mr. Tom Glasgow. He is the Chief Investment Officer Asia for Omni Bridgeway, a former senior member of Allen Overy's International Arbitration and Disputes Practice in Asia. Tom presently leads the Asian investment activities and business expansion for Omni Bridgeway, a well-known large global litigation funder, with operations spanning Asia, Australia, Canada, Europe, Middle East, the UK, and the US. Tom is also recognized as a thought leader in third-party funding by Who's Who Legal. Next, we have Mr. Alistair Henderson, Managing Partner, Southeast Asia, Herbert Smith Freehills, with over 20 years of experience handling major disputes across several sectors, including construction and infrastructure. Alistair is one of the leading names in the region. He's also on the panel of arbitrators of SIAC, HKIAC, KLRCA, and THAC. Alistair is a fellow of the Singapore Institute of Arbitrators and an expert panel member of Singapore Management University Centers for Cross-Border Commercial Law in Asia. As a managing partner, he oversees his firm's offices and affiliations throughout the region. Finally, we have Mr. Badrinath Durvasula, who is the former VP Legal and General Counsel for Hindustan Construction Company. Badri needs very little introduction to our audience today. He comes armed with not only intimidating academic qualification, expanding from an MBA in marketing to an LLM in commercial law and to a master's in nuclear physics. But over the course of his illustrious career, he has worked with and led large businesses, including Reliance Industries, Great Offshore Limited, Binani, Larsen & Toubro, Adani, and of course, most recently, Hindustan Construction Company. He has significant experience in infrastructure projects generally, and of course, hands-on experience in domestic as well as international arbitrations. So in short, we have a stellar panel today. Before we start and move on to the topic, one housekeeping matter, and I am sure you're all aware by now of the Zoom functionality, so I'll keep this very short. Please use the Q&A functionality at the bottom end of your screen to put all your queries. And if possible, please do address the questions specific to any speaker. And Pratik and I will do our best to cover all the questions at the end of the discussion. So with that introduction, we'll now quickly move on to our large agenda for today. We're trying to cover quite a few questions and themes for today's panel discussion. So the aim for at least Pratik and I intend to cover broadly 6 themes, which hopefully span the key points in thinking about litigation financing in the infrastructure sector. We will first start off with a brief overview of litigation financing, essentially covering the basics, how it works, how it does it differ from other forms of funding, and when it might be used. Second, we will cover the legal and economic considerations around litigation financing. And in doing so, we'll also discuss the legal and regulatory framework in other jurisdictions. Third, we'll consider structuring issues that often arise in finalizing litigation financing. Fourth, we will hear from the experts on important case consideration that, of course, influence the terms of litigation financing and are critical in, as they say, in closing the deal. Fifth, we'll discuss cost considerations in funded claims. And sixth, and finally, we'll bring all the themes together and consider disputes and key issues in the infrastructure sector and the panel's experience with financing such disputes. Now, going on straight to the first theme and not wasting any time. So Sindhu, can you just help us help explain what litigation financing is, how does it work, and what are its key features?
Sure, and thanks for the kind introduction, Montek. So, a classic third-party funding arrangement is any arrangement by which a litigation finance company provides funding to a claimant to bring and run a case, and in exchange shares in the winnings of the case. So if the claimant is successful when the case ends, the funder receives a portion of the winnings, and if not, the funder gets nothing. I think from this very simple definition, you get a sense of how it's quite different to some of the more traditional forms of financing out there. It's different from taking a loan out from a bank. You have to pay the loan back whether or not your case succeeds, whereas TPF is non-recourse, which means if the claimant doesn't win, they don't have to pay the funder anything. It's also quite different from selling or monetizing the claim outright, either through an outright assignment of the claim itself or by selling the underlying asset or debt, like in distressed debt or asset investing. In TPF, the claimant retains ownership and control of the litigation. And I guess it's also different from contingency fee arrangements and other financing arrangements that law firms and lawyers can provide in some jurisdictions. Funders tend to be sort of mere investors in a case and stay quite separate from the legal representation. Obviously, this kind of classic TPF is not all that's available in the market. All the other traditional forms of financing, I said, are also available. You've also got a big insurance market out there that claimants and defendants can consider. And with TPF itself, as we'll probably come on to explore, there are many, many variations on the classic model, and funders are now more than capable of covering more than one case, more than one claimant, and sort of both claimants and defendants.
Okay, thank you. Now, Tom, coming to you, flowing from that, I have sort of two questions I'd like to get your inputs on. First, so what are the benefits of litigation financing, and why should parties consider such financing in pursuing their claims? And second, to put you on a spot a little bit, how do you, i.e. the funders, make money? And is it still worthwhile for the parties after you take your share?
Sure. Okay. Well, I'll take those each in turn. And I think one of the points that Sindhu was making there is that there really is an increasing sophistication in the use of third-party funding. And one of the key shifts in our industry has been away from historically funding parties that can't afford to bring their own cases to now being used as a sophisticated corporate finance and risk management tool. And I think it's obvious what the benefits would be if you couldn't pursue your own case, you didn't have the financial means, but perhaps less obvious why financially well-resourced corporates are now turning to funding. And so perhaps I can just highlight some of those benefits to the more well-resourced corporates. One is obviously a cash flow benefit. And this is about freeing up money that you would otherwise spend on your litigation to spend elsewhere within the business. And it's a bit of an opportunity cost thing. Most businesses would prefer to invest in their core business where they know how to make a profit rather than spending money on arbitration or litigation. Secondly is the risk mitigation aspect. Funders can obviously cover the ongoing costs of disputes, but also often cover the downside. If the case is unsuccessful, then you have to pay the other side's costs. So often there's an incentive to try and reduce risk involved in a claim. Anyone that's been involved in arbitration or litigation knows that there's no such thing as a 100% case. Every case has risks. The third point is around unlocking value. Most litigation or arbitration assets are contingent assets. They sit off balance sheet. And litigation finance is unique in the way that it allows businesses to leverage that contingent assets value to bring value onto to the balance sheet. And that can be to fund the pursuit of the case, but it can also be in some circumstances to provide working capital for the business. And because it is a non-recourse arrangement, there's no corresponding liability typically that flows onto the balance sheet. So there are significant financial advantages to using this unique form of finance. There are also softer elements. If you obtain funding from a company like Omni Bridgeway with a success rate of 80 to 90%, then it sends a strong message to the other side that you've had your case vetted, it's a good case, you've got a fighting fund, and that can make them sit up and listen. Similarly, it can send messages to the tribunal or to the court, and often businesses are looking to demonstrate to their investors and their stakeholders that these are good claims and that we're managing the risk in them appropriately. So there's important messaging that flows around it as well. Those are some of the broader benefits. We make money, as Sindhu said, from a share in the successful outcome. And if there is no success, we don't make anything. It's a binary equation for us. And what is our usual share? Well, the answer is there isn't a usual. It really depends on the risk involved. We treat litigation as an investment asset class. And like any other investment asset class, the higher the risk, the higher the return that you expect. So I can't give you a clear answer to that, but it does depend on the risk involved.
So I take it that regardless of the approach you take, it's still worth it for the company after you take your share.
Absolutely. We endeavour in all arrangements to ensure that the bulk of any recoveries are going to the funded claimant. That's really important.
Okay. Thank you, Tom. Alistair, you have worked on many matters, funded and otherwise. You obviously play an essential part in developing and implementing the overall case strategy, which often might include advising on raising litigation financing. So what are your thoughts from a counsel's perspective on litigation financing? And particularly, when do you think it might be useful or helpful to consider such financing in the cases you work on?
Thanks, Montek. Sindhu and Tom have rightly identified core benefits for corporates of funding, and that is largely either to provide funding where they don't have it, or to provide financing where they have the funds but just want to use them for other more productive things. And also, by the way, de-risking the cost aspect of running litigation if the fund is going to take that on and pay the money. But from counsel's perspective, I could be facetious and say funding allows us to have more clients, and it does. It facilitates more people coming to the market, and what's not to like about that if you're counsel? But slightly more seriously, there is value in having an expert fund working on a case with you. They are a second pair of knowledgeable eyes. They're a sounding board. They bring perspective, which is well worth having, and sometimes very useful to be able to talk to people like Tom, people like Sindhu, to get their perspectives on the case that's being run. Also, from counsel's point of view, there's cost certainty, which is important. There is always going to be an element for me as counsel wanting to make sure that my next bill is going to be paid and the one after that. And if a case is being funded, then that gives me a greater degree of security and comfort taking the case on. Having said all that, actually my experience is mostly on respondent side. I have done funded cases, but I've done more respondent work against funded cases. So what is the significance there of funding on the other side of the table? Actually, in my experience, not much. I take Tom's point that the presence of funding is in some ways a sort of a certificate of worth over the case. In other words, it's gone past a basic threshold of, as this case got legs. But the reality is, in most of the work I do, we're dealing with big cases with big law firms, and those cases have probably already gone past that. I've seldom thought, my goodness, there's a fund on the other side, I better give this case more attention. So although I understand that in theory, it's not been my experience. And I have to say, there's been a couple of cases I've run where, I just don't believe that the fund has properly given it that attention. Actually, I should clarify, neither of the funds here. Funds, I think, do have, or funders do have some influence on cases in less direct ways. I see them influencing, I think, the timetable of cases. Funds want to get a return on investment, and generally speaking, they will be in favor of faster cases rather than slower cases, not to the detriment of the client or case, but if there's a choice to be made, you'll typically see a funded party with the funder behind it pushing for a quicker solution, in my experience. Occasionally, I've sensed the presence of a fund in the context of settlement discussions. Funds need to have a settlement at a certain level in order to make the return that their investors, shareholders, or their directors are looking for. And that may affect the willingness of the party to take a lower settlement. There may be some influence from the funds to push for more. Also, and importantly, for a respondents' council, it's comforting to know that there is funding on the other side which should stand behind any adverse costs order made against the claimant, provided that the fund is going to be on the hook for those costs. And I think that's something we may pick up later. Thanks, Monte.
Thank you, Alice. That was really helpful. Thank you. Badri, now coming to you. We've heard the funders, we've heard council's perspective. Now I'm very keen to get your view as a corporate, as a user of litigation funding. So my question to you is, does litigation financing make sense for companies where you have worked when pursuing claims? And again, just touching and expanding about a bit about what Sindhu was saying, how does it differ from a user's perspective, from other forms of funding you might have access to?
Thank you, Martak. I think it's a wonderful note on which we started. And before I could answer my question, let me thank the fellow panelists, the organizers, as well as the audience who are keenly watching this particular program. And I have been representing the infrastructure industry, not any particular company. I worked with Reliance, I worked with the Larsen & Toubro, I worked with the Adani Group and Hindustan Construction. So it's an aggregation of the experience which I have it over a period of time, last maybe 20, 25 years. I've seen the kind of things which pass through. And I would attack the question by giving straight away one simple example for easy comprehension of the audience. I imagine a company which has got about 1,000 crore turnover with about 25 projects on hand. I'm just talking about a mid-sized company. It's a 1,000 crore company turnover and about 25 projects in hand. Just imagine for a moment, any point of time, it will have on all the 25 projects, at least 4 kind of the dispute resolutions, 4 arbitrations, and 4 litigations, small or big as such. So all this put together, plus other kind of a disputes, whatever they have it, it's about 100 litigations or the kind of an arbitrations or dispute resolution, it will have it. If you turn it into a kind of a cash terms, the kind of a budget that need to be allocated to it, depending on whether it's an Indian-centric litigation or if it's a Paris-based ICC or a London-based LCA or a Singapore, I think the budgets need to be scaled up. I'm taking on an average almost about 100 crores kind of a budget. One need to be prepared for in terms of the kind of a costing, because looking at the senior counsels, looking at the kind of a counsel fee and that of the arbitrator's fee, plus the various other facets of the interesting aspects that I get into. So put together, it's about 100 crore, the company to set it aside for the ongoing projects in terms of the litigation costs, or it need to budget for. The second point is that this 100 crores is not going to be expended on the Y1. The 100 crores might be expended on Y2, Y3, whatever it may be. Similarly, if you look at the previous year's history, the cases will be coming onto their table with a kind of an expenses. Altogether, there'll be kind of a 200, 300 crore budget. Each of the mid-sized company need to be really ready about in terms of tackling the kind of a legal disputes as such. Let's not look at the numbers. It could be a few tens and 20s of crores this side or that side. But the point is that there is a substantive money which gets locked up in the whole stream, for which every member of the board really gets concerned as to what's happening with the litigation. So obviously, this is the kind of a situation where we need a kind of a hand-holding. We are not running the companies for the sake of fighting out the litigation. We are here for the sake of running the business and running it in a very productive manner. Unfortunately, because of the government stand in various countries, whatever it may be, and particularly more so in India, the things doesn't go through, ultimately land up in some kind of a litigation and arbitration, which is a very expensive proposition. Given this kind of a scenario, even if somebody comes with a kind of a help, whatever it may be, whether it is a hard help or an easy help, whatever it may be, the litigation financing is one such thing which comes to rescue. Every corporate would love to have it. Let's review subsequently about the terms and conditions of the thing. But point is that this is a wonderful mitigating step for the management to really consider and take it as a serious view. From my experience, let me also share with you that most of the corporates are looking at it in India very seriously, and depending on the size of the book of the litigation as well as the arbitration, they are very keen to get into this kind of a thing. I think this is the right kind of a time for the litigation financing to take off on Indian shores. That's my perspective.
Thank you very much. And of course, we will come back to you later on some of your experiences with the litigation financing. So